Hey there, I'm Paul Rabelais, and in this video we're going to talk about whether children are responsible for the credit card debts of their deceased parents. Okay, so when people hear estates, they think lots of money, millions of dollars, large estate, big old house, heirs, just collecting lots of money. But not every estate is quite so clean. Sometimes, you have somebody dies and they had assets, maybe a home, and they maybe have had a car, and they may have even had some bank accounts. But in some of these estates, there's also some debt. Sometimes a lot of debt. There's sometimes a home mortgage, sometimes there's car loans, and then sometimes there's credit card debt. So in this video, we're going to look at how or when the heirs are responsible for the debts. And in this example, let's just say there's a dad, and maybe he had a will and maybe he did not. But he had three heirs. Maybe he had a will and left everything to his three children, or maybe he didn't have a will and by law his estate goes to his three children. So first thing right off the bat, I'm gonna clear this up. And I hate to say this, but I'm here in Louisiana, and if you're watching this and you live or are dealing with an estate in another state, you really ought to check with an attorney in that state. Laws can vary from state to state. But the first thing I'll say is children or heirs, they're never personally responsible for the debts of their parents. Even if the parent had a will leaving their estate to the child's not going to have to come out of pocket to pay for the debts of the parent, unless the child signs something to obligate themselves to pay that debt. So we get that every once in a while, when dad dies and a child, maybe co-signed on a loan for dad or a credit card, and dad dies, no assets but debt, and the child's wondering why they have to pay that debt. Well, they obligated, they signed the paperwork to obligate themselves to pay that debt. So we don't see that a lot, but the general rule is a parent's debts don't pass along to the children, where the children have to come out of their own pocket to pay their parents' debts. So let me get into that in a little bit more detail. So, if dad had a will and he left his estates to his children, and he had, let's say he had $200,000 in debt, and his only asset was a $60,000 bank account. And right after dad died, because maybe a child's name was on dad's bank account as having signature authority, right after dad died, one of the kids went and cleaned out his $60,000 bank account. But dad still has $200,000 of debts. Well, the children are may be in a position where they're going to have to kind of give that $60,000 back to pay off some of dad's $200,000 of debt. Now, the kids aren't going to have to pay their own money back, but to the extent they got $60,000, there's all the authority in the law that says they're going to have to give that back if whoever was owed that $200,000 pursues their claim. So let's look at credit cards in a little bit more detail, and at the end I'll have some advice for you as to what to do if you had a loved one who had several credit card debts outstanding. So when there's debt, at the top of the priority chain are things like a mortgage, which is secured by the home or property, or maybe a car loan that is secured by the vehicle. And then below them are the credit card companies. Those are unsecured debt behind the mortgage, behind the car loan lender. So let's look at an example where dad died. He had a home. It was worth $200,000, but he still had a $100,000 mortgage. He had a $15,000 car, still had $10,000 he owed on the car, and then he had 8 different credit card accounts, and the total of those were $40,000 that he owed on to those credit card companies. So what will happen there is, the estate or the executor of the estate or the court-appointed administrator of the estate, if dad had no will, going to have to go through a process, sell that home, pay off that $100,000 mortgage. That happens, automatically when the home gets sold because it's a secured debt. Probably sell the car for $15,000 or something like that, pay off the $10,000 car loan. And then those funds that are available or are part of the estate would have to be used to pay off the $40,000 credit card debt before anything can be divided up among the 3 children. So if we do the math, sold the $200,000 home, paid a $100,000 mortgage, so there's $100,000 in cash left. Sold a $15,000 car, paid off $10,000 of debt. That's another $5,000 of cash. So there's $105,000 of cash, $40,000 of credit card debt, leaving $65,000 to be divided up among the 3 children if that's the case. All right, so it is interesting to note, however, that some credit card companies, there's no authority in the law for this whatsoever. Maybe these credit card companies are making business decisions, but some credit card companies will forgive the debt of the credit card account holder who died and had a balance on his or her credit card. Like I said before, I'm going to say it again. There's no authority in the law where the heirs can require that credit card company to just forgive the debt that is due. But sometimes, and maybe they do it for 2 reasons. Either they don't want to go hire expensive lawyers to have to file claims in the estate that would be necessary in order to collect the $2,000 credit card balance or the $10,000 credit card balance. Or maybe they're just doing it out of goodwill because they don't want to get a bad name. I doubt that. I think it's more the former than the latter. But in some cases, credit card companies will either accept pennies on the dollar to close out an account on behalf of a deceased person. Or sometimes, we've had many children of deceased, credit card account holders come in and say, we called the credit card company. They just told us to send them a death certificate, which we did, and they forgave the balance. So again, no obligation that they have to do it, but there's a what does the law say and what's practical? We kind of see on that practical side that credit card companies, I think they just don't want to mess with all of the bureaucracy and procedure of trying to collect a debt through a succession or through a probate or through an estate. So they just waive it or accept pennies on the dollar. Okay, so it gets more complicated though when you have that scenario where there's a home with a mortgage and a car with a car loan and there's more debt than remaining cash. Or maybe there is no home with a mortgage or car with a car loan. Let's say, for example, or let's say there is. Sell the car, sell the house, but even after you sell the home and sell the car, after you paid off the home mortgage and the car loan, let's say there was only $40,000 of cash remaining, and then there's $80,000 of credit card debt. There might be 15 credit card companies. Well, what does the law say there? $40,000 of cash, $80,000 of unsecured debt. In theory, every credit card company or unsecured debt, they're going to get half their money because there's only $40,000 of cash but $80,000 of debt. The mortgage company is going to get paid in full. The car loan lender is going to get paid in full, and then the credit card company, they'd be those debts would be charged ratably, is what our law says. So, bottom line on that is when you're involved in a estate and maybe a parent passed away and there's some credit card debt, I do think it is important that you communicate with the credit card companies. I do find them to be somewhat lenient when they find out, a child calls, says, look, my mother passed away. I understand they had a balance. I do find that they are sympathetic in many cases where they'll stop accruing interest or, if there's no payments made for some time, they're not going to go crazy. Now look, everyone's different, so feel free to share your experiences in the comments below. Everybody can benefit from that. But I will say that if the estate has assets, the estate is responsible for paying those debts. In some cases, credit card companies are willing to accept pennies on the dollar or just forgive the debt entirely to kind of quote unquote get it off of their books. So feel free to explore that as an opportunity, but that should give you some guidance on this difference of an estate debt when it's secured versus unsecured. The secured debt, is higher in the priority chain than the unsecured debt. Know that heirs never have to come out of their pocket to pay for the debts of someone who died, but if the heirs received an inheritance and following the proper procedures, debts surface, an heir may in certain circumstances be obligated to give that inheritance back in order to pay for that debt if it's if the creditor followed all the procedural rules correctly. So hope that helps on a little bit on estate debts. It's just part of life and death. Some people die and they have some debt, have some significant debt, and so it's just an issue, not necessarily a fun one, but one we have to deal with from time to time. It happens. All right, y'all have a great day. Take care.